Good morning. It is 9 a.m. on August 20th, 2025. I'm Commissioner Megan Gilman. Chair Blank is not joining us this morning. So just you and I, Commissioner Plant.
All right, sounds good.
We'll try and keep it on the rails. Um, First, Commissioner Plant, I'll go to you with any action on the consent agenda or any opening remarks today.
Nope, I have no opening remarks. I would approve the consent agenda.
Thank you. I would also vote to approve the consent agenda. First item up on our discussion agenda in transportation proceeding number 25A-0129R, City and County of Denver. Go ahead, Mr. Farrell.
Thank you. Good morning, Commissioners. Alan Farrell with the Rail and Transit Safety Section, here in relation to 25A-0129R. And on March 25th, 2025, Denver filed an application to add protected bike lanes on Green Valley Ranch Boulevard under RTD's A-Line overpass in Denver. Denver proposes to add eastbound and westbound bike lanes to connect to the existing bike lanes on the east side of Tower Road on Green Ranch Valley Boulevard. By decision number C-25-0422, issued on June 4th, 2025, the Commission deemed the application complete, granted the application, and required Denver to file a copy of the signed Construction and Maintenance Agreement, or C&M Agreement, for this project by June 20th of 2025, prior to starting work at the crossing. On July 18th, 2025, Denver filed its Motion 1, requesting a variance of the requirement in decision number C-25-0442 for Denver to file a signed C&M agreement with RTD for this project. In support of this Motion 1, Denver states the city's general contractor and RTD have entered into an agreement that outlines the terms for the design, construction, operation, and maintenance of the crossing, and filed a true and correct copy of the agreement in the proceeding. On July 31st, 2025, Denver filed Motion 2, also requesting a variance of the requirement to file a C&M agreement with RTD. Motion 2 states the minimum vertical clearance between Denver's proposed bicycle path and RTD's bridge structure is 17 feet and 6 inches, and the Denver's work will not require to touch or interfere with RTD's bridge structure. Denver's motion states Denver will be solely responsible for maintaining its bike lanes. For these reasons, Denver does not believe a C&M agreement is necessary in this instance. And RTD does not oppose the motion. And unless you have any questions, I have a recommendation.
Thanks, Mr. Farrell. I think you can go ahead with your recommendation.
Thank you. Staff recommends the Commission grant the motions filed by Denver for a variance of the requirement to file a signed C&M agreement with RTD, and that the remaining compliance ordered in decision number C-25-0422 remains as required.
Commissioner Plant.
I agree.
I also agree. Thanks, Mr. Farrell. Appreciate it.
Thank you. Thank you, Commissioners.
Next item on our agenda is proceeding number 24A-0547E, Public Service Company of Colorado Distribution System Plan. I think we're going to Ms. Dundas. Am I right?
Good morning, Commissioners. Can you hear me?
Yes.
Sorry for the cough, but I'm going to present one motion, and then Mr. Foreman will present another motion in this proceeding. As you're aware, the Commission received 2 settlement agreements last week in the DSP proceeding. One relates to the virtual power plant issues, and one relates to the non-wires alternatives / targeted distribution area issues. Both parties are supported, or both settlements are supported by different collections of parties, and the company filed a combined motion to approve both settlements as well as the GMAC stipulation on Friday, August 15th, which was the extended deadline for settlement agreements and settlement testimony. In their motion, they make a few requests in addition to approving the agreements, including that settlement testimony be due yesterday, August 19th, and any settlement testimony opposing the motion be due Thursday at noon. Thursday is the 21st. They also require responses, or they also request that responses be filed by that same deadline of August 21st at noon. And they request that the AVPP issues be taken up in the first few days of hearing. I have a recommendation as to what to do with this motion today, if you'd like.
Yeah, go for it.
Thanks. Obviously, I don't think it's appropriate to rule on the substance of whether to approve these settlement agreements now. I think that's something that you should take up at final deliberations. To that end, I don't think it's appropriate to set a response deadline of tomorrow at noon to the motion. Typically, parties respond to or parties that don't join settlement agreements respond to those settlement agreements through SOPs and through their presentations at hearing. While of course they could respond to the motion, I don't think rushing those responses on the substance of the settlement agreements is in the commission's best interest. So I would set a response deadline of noon, August 21st, just to the procedural issues in the motion, if anyone chooses to respond to those, but that the substance of the motion could be responded to in due course. I'd also recommend granting the request that tomorrow at noon be the deadline for any final testimony regarding the settlement agreements. But a couple notes there is that obviously that Tuesday deadline has already passed, so I'd recommend you accept those filings, and any fights over whether they should be in the record or not can be taken up at hearing. And then also just a notice to the parties that any testimony filed tomorrow would have to get entered into the record at hearing because it won't make it onto the exhibit spreadsheet. Sorry, that was a lot.
You got it. All right, Commissioner Plant, do you need those broken down or are you ready?
I think I would approve them en masse,
Great.
if I can do that.
I too agree to each of your recommendations, Ms. Dundas.
And then just a reminder to the parties for the DSP, we will convene tomorrow at 2 p.m. for a pre-hearing conference. And then I'll hand it over to Mr. Foreman. Thanks.
Yeah, Mr. Foreman.
Good morning, commissioners. Wyatt Foreman of your commission council. Before you here is a decision whether to grant the unopposed motion for extraordinary protection for certain engineering memoranda filed on August 18th, 2025 by Public Service Company of Colorado. In its motion, the company explains that intervener trial staff has requested that it respond to an interrogatory and a discovery request with information regarding the process for planning distribution feed projects. The company states it has determined that non-public and sensitive internal engineering memoranda relating to the planning process for distribution feeders, along with any attachments to such memoranda within the category of highly confidential information, are responsive to staff's request. Public Service asserts it treats the internal memoranda at issue as highly confidential because they reveal proprietary, non-public, and location-specific details regarding the structure and operation of the company's distribution system. And the company further asserts that if such information were disclosed to an outside party, it would create security concerns for the distribution grid, the company's customers, and the company employees. The company also asserts the memoranda at issue contain detailed maps that warrant the same protections granted by the commission regarding the company's first MEP in this proceeding. The company states it intends to produce a demonstrative examples of the engineering memoranda in question as attachments to a supplemental response to staff's request, and that in order to provide the unredacted versions of the memoranda, the company seeks extraordinary protection here to provide these documents with a highly confidential designation. The company further states that if the motion is granted, it will make the highly confidential information available to the commission, staff, and to representatives and counsel for the parties who have signed the appropriate highly confidential NDA. The company clarifies that its request includes any documents discussing or identifying any of the indicated highly confidential information, including all testimony, discovery responses, including attachments, hearing transcripts, decisions, and any other associated documents containing such types of information as may be provided throughout the course of the proceeding. Public Service requested access to the information be limited to the commissioners, the ALJ, if any, the commission's advisory staff and advisory attorneys, trial staff and attorneys for trial staff, and a reasonable number of representatives and counsel for the parties to this proceeding. The company further asserts that the requested protections strike the appropriate balance between the need for disclosure within the confines of the proceeding and the need to protect the interests of Public Service, its customers, and the distribution grid. Company also maintains the request is reasonable in the public interest and consistent with past commission decisions. And because the motion is unopposed, Public Service requests a waiver of response time pursuant to Commission Rule 1308C. And I can offer a recommendation here. Council recommends granting the company's motion under Commission Rule 1101B. A party seeking extraordinary protection of highly confidential material must include a showing that the information for which the highly confidential protection is sought is highly confidential, that the protection afforded by the Commission's rules for furnishing confidential information provides insufficient protection for the information, and if adopted, the highly confidential protections will afford sufficient protection. Here, the motion is unopposed, and council believes the reasoning and arguments in the motion are persuasive. Motion states good cause to grant the relief sought under Rule 1101, and the requested protections are appropriate, reasonable, and consistent with the Commission's rules and past practice. Council therefore recommends granting the motion and waiving remaining response time.
Commissioner Plant?
I agree.
I also agree.
Okay. I think I'm on for one more.
Okay.
I think in the 25A0266E.
Oh, are we done with
I think that's it for.
Okay.
Yeah, that's it for the DSP, and we'll issue an ABC order granting in part that motion that I discussed, and then granting in full the motion.
Yes.
Perfect, no worries. Okay, we'll move on to 25A-0266E Tri-State Generation Transmission. Go ahead, Mr. Foreman.
Another motion for extraordinary protection here. The decision point for before you here is whether to grant the motion for extraordinary protection filed by Tri-State Generation Transmission Association on August 6, 2025. Last week, the commission set a shortened response time to the motion in recognition of intervener Black Hills Colorado Electric reserving its right to respond to the motion. The response time was set for Friday, August 15th. No responses were filed, and the motion is unopposed. I can now describe the motion and give a recommendation on the merits. Just as a quick reminder, this proceeding involves Tri-State's application requesting a finding that the Southwest Power Pool Regional Transmission Organization in the Western Interconnection, or SPP-RTO West, is a statutory organized wholesale market as defined in Commission Rule 3752N, and that Tri-State's planned participation in the SPP-RTO West is in the public interest. In its motion, Tri-State explains that as part of the intervener trial staff's second set of written discovery requests, staff requested that Tri-State identify which of its 2023 Electric Resource Plan or ERP bids are in which interconnection status, including any updates if any status has changed since June 5th, 2025, and to provide the earliest anticipated date by which an interconnection agreement could potentially be signed for each. Tri-State further explains that it provides its interconnection queue publicly on its open access same time information system. It does not publicly list specific interconnection customer information until a customer executes a large generator interconnection agreement, or LGIA. Tri-State also explains this practice ensures compliance with its open access transmission tariff, or OATT, which requires that Tri-State keep interconnection customer identifying information confidential until the execution of an LGIA. In addition, Tri-State states its ERP is currently pending before the Commission, and as a result, it has not yet executed agreements, such as power purchase agreements, to secure the resources described in its ERP. Tri-State seeks extraordinary protection for the categories of documents and information it collectively refers to highly confidential information. Specifically, it seeks extraordinary protection for interconnection customer information, including interconnection status for particular bids in its 2023 ERP, and certain resources, sales, and load detail for preliminary SPP RTO expansion planning reserve margin analysis. In support, Tri-State asserts that disclosure of the information could cause irreparable harm to Tri-State's operations or negotiations with interconnection customers if disclosed. And it also asserts that the highly confidential information is competitively sensitive and could advantage its competitors' ability to assess particular bids in the 2023 ERP and potentially compete for those or similar projects. Tri-State maintains the categories of information for which it requests extraordinary protection are similar to information for which the Commission has provided extraordinary protection in previous proceedings, such as its 2023 and 2020 ERPs. Tri-State therefore requests that access to the information be limited to only parties to the proceeding that are not Tri-State competitors. Tri-State defines competitors as including the representatives and attorneys for other public utilities and their affiliates, independent power producers and their affiliates, and any other company and their affiliates with business functions that include the sale of energy or the development of facilities for the production of energy. Tri-State further asks that for parties that are not competitors of Tri-State, access to the highly confidential information be further limited to a reasonable number of attorneys and a reasonable number of subject matter experts. Finally, Tri-State requests individuals accessing the information, with the exception of the commission and commission trial staff, be required to execute a highly confidential NDA that is provided as an attachment to the motion. And I can proceed to offer a recommendation here as well.
Yeah, go ahead.
Council believes the company's motion comports with the requirements in Rule 1101 and states good cause to grant the requested protections. Again, the motion is unopposed, and council believes the requested protections are appropriate, reasonable, and consistent with the commission's rules and past practice.
Thanks, Mr. Foreman. Commissioner Plant.
I agree with the recommendation.
I also agree.
All right, thank you.
Thanks, Mr. Foreman. Next up, we've got Mr. Davis, it looks like, proceeding number 25A-0282G Atmos Energy GPIM. Mr. Davis, are you taking this with the next one as well?
Yes, if I could
Okay.
take the final two items together, I will.
Yep, and the next one is 25A-0283G Black Hills, Colorado Gas GPIM. So, go ahead.
Great, thank you. Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. On June 30th, Atmos Energy Corporation and Black Hills, Colorado Gas each filed an application to implement a gas performance incentive mechanism, or GPIM. The GPIMs from Atmos and Black Hills, the two investor-owned gas utilities in Colorado with the second and third largest customer counts, was a concept revisited in the GCA, or Gas Cost Adjustment, rulemaking following the enactment of Senate Bill 23-291. The updated GCA rules require both Atmos and Black Hills to file an application for a GPIM with the following minimum components: a proposed methodology to set a GPIM benchmark based on verifiable reported market indices for gas commodity costs with reasonable adjustments and for appropriate locations, a description and explanation of all gas volumes to be included in the performance measure, a description and explanation of the associated upstream costs included in the risk-sharing mechanism, and a risk-sharing amount, or the method for calculating the risk-sharing amount by formula to calculate a percentage of the difference between the actual gas costs incurred and that benchmark, either positive or negative, borne or retained by the utility, subject to certain limitations. The GPIM may have a deadband around the benchmark, whereby price variation within the deadband is excluded from the risk-sharing formula, and the GPIM can be subject to a cap or a floor based on the results of the risk sharing. Plus, the GPIM should include an approach for applying force majeure or similar provisions, and those would be applied to this risk sharing mechanism. As I stated earlier, the GPIMs proposed by Atmos and Black Hills are intended to be consistent with the GCA rules that were modified just prior to the enactment of 23-291, but which the Commission later found were nonetheless consistent with the requirements of 23-291 in the second recent GCA rulemaking. And recall that the GPIM rule adopted prior to 291 was the result of a consensus and negotiation between staff of the PUC, the gas utilities, and other interested parties, unlike the GPIM framework that now applies only to public service post-Senate Bill 291. Only staff has filed interventions in these two proceedings and requests hearings for both. Staff states, however, that it's intervening to spend additional time reviewing the application before determining whether it in fact opposes the relief sought. Both applications were deemed complete by operation of the Commission's rules last Friday, August 15th. So the question before you now is whether to set these two applications for hearing, and I can provide a recommendation if you'd like.
Yeah, go ahead. Thanks.
I recommend that the Commission refer each case, including staff's interventions, to an administrative law judge by minute entry.
Commissioner Plant?
I agree with the recommendation.
I also agree, Mr. Davis.
Thank you.
Thank you. Well, unless anyone stops me, I think that was it for the agenda today. Anything additional, Commissioner Plant?
No, I have nothing additional. Thank you. Good job, Madam Chair.
Hey, some, somehow I didn't make a huge mistake.
Somebody FedExed you the gavel, I'm sure.
Yeah, of course. Yeah. Okay, perfect. Well, thank you so much. Appreciate it. And we'll see y'all for the deliberation meetings coming up starting tomorrow. Bye.